TK Runkles Pearson.
Mark Comstock.
Susan Gravy, Oregon State Bar.
Rebecca Duncan.
Jean Ann Quinn, sitting in for Chief Judge Jim Egan.
Okay. And on the phone, we have John Perry. We know we've got John Perry. Judge Bouchon.
Yes, I'm here.
Who else do we have on there?
DiLorenzo's on the phone.
Hello?
Yep.
Susan Gary.
Oh, Susan, great.
Keith Dubanovich.
Okay, welcome, Keith.
And that should be it.
Okay, all right, so we got our quorum. Excuse me. The first item of business is to review the report, the proposed bills from the Probate Modernization Work Group. Susan, since I'm here, I'll lead off on that and then ask you to back clean up. Is that all right?
Great.
Okay. You have before you a draft report by Professor Gary, and you have 3 legislative concepts that are ready to be introduced as Law Commission bills. There's a lot to them. Most of what these do are more cleanup than material and headline making changes. But I will walk you through some of the more salient portions of the bills, and then be glad to answer questions. LC 2957 is primarily a bill addressed at what we call no asset estates. These are estates where you have to file to have a personal representative appointed, perhaps for the purpose of exercising a power of appointment, maybe for pursuing a wrongful death claim, or for some reason to have the authority to take an action as a personal representative, but you're not actually probating any assets. And the challenge with that has been that once you open an estate, you are in an estate and you go through all of the steps of the estate, everything from A to Z to get out. And in an estate where you really don't have any assets that you're administering, that creates extra time and expense for both the personal representative and the lawyer and the courts. So in LC 2957, you have these things. In section 1, we simply say that if this is a no asset estate, you have to say that it's a no asset estate. You're not actually probating any assets, and then you have to say the reason why you're filing the petition. That's being added as a requirement in the filing of a petition for appointment. And then the next sections deal with processes and requirements that will not apply to these no asset estates unless assets are found, in which case, of course, then it becomes an asset estate. No bond in section 2, no bond is required if there's no assets. In section 3, no requirement to publish notice to interested persons for a no asset estate. In section 4, no duty to file an inventory. In all of these, if assets are discovered during the course of administering the no asset estate, then you go back and do all these things. But if it's a no asset estate, then these things are waived for the duration. In section 6, notice to creditors is not required in a no asset estate. And in section 7, if a personal representative receives a claim from a creditor in a no asset estate, no response is required. Again, if assets later become discovered, then the regular claim and response process applies. In section 8 and 9, again, in a no asset estate, rather than filing a final accounting where there have been no assets, that simplifies the process for closing a no asset estate and getting an order of discharge. Section 10 amends is an amendment not to a no asset estate, but it's within the subject matter of the relating clause. It relates to regular probate estates and the requirement of filing an annual accounting. As those of you who are practitioners know, when you get to the end of a probate estate, you can file a statement in lieu of final account with the consent of all of the beneficiaries, and that saves the time and expense of compiling and serving an accounting. That opportunity does not exist with respect to annual accountings. There's no option under current law similar to that for an annual accounting. Section 10 creates the ability to file a statement in lieu of an annual accounting. In that case, the distributees must consent in writing, the same as in a statement in lieu of final account at the end of the estate. And creditors are not required to consent, but any unpaid creditors have to be sent a copy of the statement in lieu of the annual accounting. And as a measure of protection for creditors, and this was an interest of the courts, if a creditor feels they have reason to want to see an accounting, all they have to do is give notice to the personal representative that they want to see an accounting, and the personal representative has to file an accounting. There's no motion practice required. It's just a matter of, basically, it's non-consent after the fact. So in most cases, we think that are appropriate for this, it'll be no problem. All the beneficiaries, the distributees will consent. There may not be any unpaid creditors. If there are, the PR will have been in touch with them. And so for the appropriate case, a statement in lieu of an annual accounting will be a streamlining element that will make probate simpler in the appropriate cases. Section 3A, I'll just mention that. There's a mention in at the bottom of page 4 in the report that this statement in lieu of an annual account is available unless otherwise provided by order of the court. We did leave the court the ability to enter an order saying, no, I want an accounting. In the report, we've made the legislative history that what we mean there is an order entered in a particular case based on circumstances that are particular to the estate, and not a blanket order entered by a court that says we will not accept statements in lieu of final accounts in lieu of annual accounts in estates. That was a concern of members of the work group, that if we authorize courts to enter an order not allowing a statement in lieu of annual account, that there are courts that might enter such an order and just prohibit them, and that's not the intent of that language allowing court orders to disallow statements in lieu of annual accountings. That's pretty much House Bill 20, or LC 2957. Susan, did you want to add anything?
No, I think that covers it. Thank you.
All right. Any questions?
No.
All right, then I'll go on to LC 2960. This is small estates. And I'll do the same thing here, just kind of walking through. I'm really using the report as the script. We've actually, in section 1, added a definition of small estate affidavit, which we've never had before. I don't know, if for those of you who practice, small estates are just kind of a strange thing. The courts tell us that about 95% of small estates are done pro se. And so the courts see a lot of them. Us attorneys don't see them so much. Sometimes a small estate will be used if you've got a trust and you want to cover notice to creditors, to cut off creditors' rights, and you don't want to administer the trust. You might use a small estate, or there might be a small bank account left outside of a trust that needs to be administered. But lawyers don't generally see small estates. And in looking at these statutes, what we find is it's really hard to follow the process if you actually read the statutes. We hope that we've rationalized it a little bit and provided a little bit more guidance in case anybody ever has to actually look at what the rules are. Sections 2 and 3 deal with valuation. The question came up in the work group, and I guess it's been a question for the courts. Of course, we have the statutory limits, $75,000 for personal property, $200,000 for real property in order to qualify an estate for a small estate. You have a situation where sometimes an asset is not discovered until some years after the date of the decedent's death. What date do you use for valuing the small estate? Do you use the date of death, which at this point, if you're administering the estate many years after the date of the death, might not be very relevant to the procedures and what we would expect in the way of protections in administering an estate if an asset is appreciated in value from below the limit to above the limit. So what we've done in these two sections is we say the valuation has to be within 45 days of the date of the decedent's death, of the filing, rather. Is that right, Susan? Or is it date of death if, no, it's within 45 days. And so we thought about using the date of filing, but that's impractical because stock accounts and things like that will change in value, and it's a moving target. Again, date of death will not always be a fair indicator of the value for the purpose of the administration going forward, and so we've chosen the date within 45 days prior to the filing of the affidavit. That will be the date at which the value is determined. In section 4, we have a new provision that clarifies that if in filing an amended small estate affidavit where you've discovered assets after you've filed an initial affidavit, if you discover assets that take you over the valuation, the affiant's authority is terminated immediately. In that case, their only authority is to turn the assets over to a personal representative, because at that point they are functioning outside of the value limits of a small estate proceeding. We've also amended a rule in current law that you have to wait 30 days after the date of the decedent's death in order to file a small estate affidavit, and then the statute says you have to wait 10 days after that before you can present the affidavit to a bank or to anybody to take possession of any property. The committee that has looked at this and practitioners have dealt with it feel like with the 30 days that you're waiting to file, the extra 10 days is really unnecessary, so we've eliminated that 10 days after the filing. So an affiant can begin to act within their authority on the filing of the small estate affidavit. I'll look ahead to things that are more, I think, substantive. I'm sorry, that's in section 8 that I just talked about. I want to go to section 13. Is that it? Oh, I see. No. Susan, where is it about compelling delivery? Oh, there it is. It's in section 8. This is on page 7 of the report. This is something that, one of the reasons when we started this, we looked at the possibility of creating a non-intervention probate like they have in Washington, where you can just do an estate without court supervision, basically. And the reason is again, practitioners know in a small estate you don't get letters testamentary or letters of administration. But so many banks agents for stocks, transfer agents, don't recognize a small estate affidavit. They want letters testamentary or they want letters of administration. You tell them, well, we don't have it, it's a small estate. We don't need letters testamentary, please deliver us the money or liquidate the stock. And I see it on the listserv all the time, problems that practitioners have with clients who can't get at assets in a small estate proceeding simply because an entity doesn't recognize the legal force of a small estate proceeding or a small estate affidavit and insists on letters testamentary even when you don't have an estate that requires formal probate. So what we've done in this case to sort of give some authority to affiants in section 8, if a person that's holding assets or owes a debt to a decedent refuses to turn that asset over or that debt, this section authorizes the affiant to request the assistance of the court to compel the delivery and allows them to recover attorney fees, unless the party had a reasonable cause not to turn over the asset. So it's a little extra force that we'll have in the future, I think, to compel compliance with our small estate affidavits. Of course, the award of attorney fees is mutual in that if the court finds that the affiant made the request without grounds or without reasonable grounds for making the demand, then the party holding the property can recover attorney fees. But we think this will be a useful tool to make small estate affidavits effective for collecting assets, particularly from institutions. I'm looking here. I think most of the rest of this is pretty technical stuff in the small estate. We do make clear in this bill that an affiant is a fiduciary. That's literal spelling out of something that has been presumed. We say that about personal representatives in formal probate estates. We do not say that about affiants in small estate proceedings, but they are handling property that for the benefit of others and for creditors. So we have explicitly said that they are a fiduciary in this. Susan, anything else you want to point out about the small estate affidavit?
Yeah, did you talk, maybe I missed it, but did you talk specifically about section 7, which is the information in the affidavit?
No, I elided
I
over
think
that.
I think
Go
you
ahead.
jumped to 8, and I think one of the things that we wanted to do is to strengthen the guidance that the affiants, because most of them are pro se, we wanted to strengthen the guidance that they're getting about what it is they're supposed to be doing, so what their duties are, which is part of the reason that the duty to, that they are acting as a fiduciary. We included that in the statutes. They always have been. It's a clarification, but it's an attempt to try to point out that this is a serious process, and the affidavit itself now has to include more information than it did before. Part of that is just a reminder to the affiant, okay, here are the things that you are supposed to do, and you're saying in the affidavit that you either have done them or you are going to do them. And there are a couple of other interesting things. One was to allow the affiant to state an electronic address if the affiant wanted to authorize creditors to file claims that way. So a few things that we thought would be helpful all the way around.
Okay. Thank you, Susan. And that change to allow presentment of claims to an electronic address tracks with the changes we've already made to the formal probate process, where a PR in providing notice to creditors can give an email address for, or a fax, I think, to creditors for the presentment of claims. Any questions on LC 2960? Yeah, Judge.
Rebecca Duncan. So Chair Witt, I just had a few questions on this one, and one was concerning section in the LC section 4, and it sets out that their disqualifications from serving as an affiant include the same ones as acting as a personal representative.
Right.
Then it also adds that if a person is convicted of a felony in Oregon or another jurisdiction. And I was wondering about the addition of the prior felony conviction, if it's not required, if it is not a basis for disqualification as a PR, is there a reason why it's a disqualification for an affiant? And if there a reason why the date of the conviction doesn't matter?
Help me remember that. Susan, do you recall that discussion? I mean, I recall it generally.
I think it is a disqualification for PR. I can check that while we're.
I'm looking for it right now. Yeah.
I think it was, and we wanted to identify it separately as a kind of more critical disqualification. But I think it is a disqualification for personal.
It's ORS 113092, and I think it's not an explicit disqualification, but it requires that in the case of a formal probate, that the personal representative, here we are, shall not disqualify a nominee if the court finds the underlying basically there's a court determination, and in a small estate proceeding the courts aren't involved, and so there's no way for a court to make a determination whether a felony is of a nature that should disqualify a PR. So I think we opted for disqualification simply because you're not in front of a judge when you file a small estate affidavit, and I guess we erred on the side probably of protection. Yeah.
Yeah, because the word was unless, so with the court not being involved, there was no way to make that determination.
Right, that was it. But yeah, that's a good question. Thank you for that.
And another question.
Justice Duncan.
With respect to section 4.
Yep.
In the report on page 6, it does explain that if the affiant took actions for when the value of the assets exceeded the limit, those actions are subject to review by the court and the subsequently appointed PR. Is that in section 4 or is that somewhere else?
That would be in the formal probate statutes. Yeah, the court can look back to actions that have been taken before the filing of the estate. Mark?
I have a question on the motion to compel payment of an asset or whatever.
Yeah.
Section 8. It specifically provides that the affiant may file a motion to compel payment. In my mind, that doesn't seem to be very effective. First, there's no proceeding. I mean, if it's a small estate. And second, at least in my experience, the out-of-state bank that may be holding 3 shares of General Motors doesn't really care about an order from a court. They may respond to a judgment that says you shall do this. I'm just wondering, is there a better way of approaching this, saying may file an action seeking a judgment instead of a motion to compel? But I see that as you get an order to compel, and Mellon Bank out there says, file an action and file it in federal court so we can actually do something. But I'm just wondering, is that really a remedy here? And it's on page 10, Bill.
Yep, page 10, it's in section 6 at the bottom of page 10. The affiant may, and as you can also tell, commissioners, of all the things we did, we were not able to agree on the bill. It is how to say affiant. Which leads me to digress just a little bit. I'm on the Uniform Law Commission, and Professor Gary knows this well, and we all snigger at Connecticut. The Connecticut, which is seems to be the only state in the country where they say conservator, conservator. I have no idea how that happened, but okay. So yeah, we've got an affiant or a fiant or whatever the case may be. Okay, so subsection 6, if a person refuses to pay a debt, delivers, etc., the affiant may file a motion to compel payment, and the court may award reasonable attorney fees. I want to work this through. In the small estate proceeding, you have other ways of bringing a court into this non-court proceeding. One is a motion for summary determination, where the court can determine a claim, and that does not result in a judgment, but it results in a determination. And then you have a motion for summary review, which is the means by which you convert an order to a judgment. And a summary review does actually result in a judgment. I guess in the context of a small estate proceeding, what I would see here would be a 2-part process where you have this motion to compel with the determination of attorney fees that then is enforceable, where the affiant can file a summary determination and get a judgment that way through the small estate proceeding. That's your path to a judgment now in a small estate. But it's an easy one. We will be doing some clarifying amendments, I am sure, as we go through this, and I'll keep that in mind if we need to make that clear, how to get that judgment. Because obviously the point is to make this a real threat, a tool, I should say, and not an empty one. So I'll take that to heart to see if there's a way we can better state that to make it a sharper instrument.
I have a separate matter, so we'll make sure this is resolved. I want to return to what Justice Duncan was raising, this issue of the felony conviction. And it concerns me somewhat because it's fairly well known, I believe, that felon disenfranchisement is a real problem in our society, and that it's biased towards folks who are historically disenfranchised in many other ways. I wonder if the committee considered or would be willing to consider if there's some way as a felony to go before a judge in the same way that someone who is asking for that consideration as a personal representative would be. That way, at least it's not an absolute bar, and the court would be able to consider the circumstances of the felony conviction.
Okay, let me suggest this, and I'll take that to heart as well. And remind me again what section?
Looks like we're talking about
Page 3. Okay, I just want to make sure I make a star on the right page here. Yeah, there it is. the only reason I hesitate about that is in our conversations about this, the courts are conscious of not creating too many paths to a judge in a small estate proceeding. That it's supposed to be done without the judge's involvement to the extent possible. And so this is just one more path to get to a judge, to bring in a small estate proceeding in front of a judge. I'm sure open to that. I would want to have conversations with our court members of the work group. Certainly this commission could decide that we're going to make a change one way or the other. But if you're willing, I guess what I would do would be to take this back to our court members of the work group and see if there's a way that we could do that without incurring basically opposition from judges about another opening to the courts to get small estates into them.
Of course, yeah, but further consideration, I would
Okay.
appreciate.
Okay,
I might be able to suggest a non-court intervention process, which would be perhaps you could consider borrowing the same as the evidentiary rule, which says you can use convictions to impeach people. There are limits on when you can use those convictions, with the idea that at some point they get so old that they're not particularly valuable as impeachment. And if the idea is we don't want people who've been convicted of felonies being affiant, it's because of concerns about their credibility. And so it might make sense to look to the evidence code on impeachment by a prior conviction, because that's also related to. That also reflects judgments about
sure,
the credibility.
sure. I would just add on that, and I don't know. Is it the same for all? I'm sure.
I think there's exceptions for perjury and other crimes of dishonesty, and so you might be able to parallel it if you have, so it's crimes except, and then maybe just a permanent use of the conviction for impeachment purposes if it's crimes of perjury or dishonesty.
Okay,
Something to think about.
all right, I appreciate that. Or you could look at crimes, class of crimes, perjury, fraud, theft. Okay,
Somewhere at 40.355, if,
all right. So for both of you, I will take that back and we'll see. Again, I hate to build too big a structure for an issue that's probably rarely in front of, probably rarely occurs. But I'm sure willing to. I appreciate the input on that. Anything else?
Can I ask a question?
Yeah.
About Section 8, and this does seem like a significant decision.
Okay.
About eliminating the 10-day period, and I
Yes.
understand that's been done because we now have the 30-day period from
Right.
its death to file.
That's right.
And so this is just my lack of understanding of how the entire scheme works, but I'm wondering if there's a possibility about a dispute by the person who's the affiant. The way Section 8 would work is that person can file and then the same day demand the property. That seems to make sense if you're dealing with large institutions, which might be directed at.
Mm-hmm.
But if perhaps, is it likely that this would be an interfamily dispute or something where somebody files the affidavit, someone else says you have no basis for doing that? That can't be resolved before a demand under Section 8 for turning over the property can be properly made. So I'm wondering if there's reason to build in time for a challenge to the authority of the affiant, and if there's not, then this is fine, but it occurred to me that that could happen.
I would say among the practitioners and the judges on the work group, that wasn't expressed as a concern. Of course, who can file is a pretty black and white test. And if you fall within the class of people who are authorized to file a small estate affidavit, you can file. And there may be 10 people authorized to file a small estate affidavit. But right now, it's the first one to get to the courthouse to file it. And the fact that somebody else is second doesn't give them, any basis to say, well, I would have been better, because there's as long as you meet the minimum qualifications, you're hired. Of course, if there are issues about conduct, or if somebody believes that somebody in fact is not qualified, they can file a motion and basically put everything on hold, I suppose. But I guess I would say, again, from the practitioners and the judges, this, of all the things that were raised as issues, I don't recall that being one. And most people thought that 10 days seemed to be just kind of an extra time that slowed things down. Professor Gary, do you have any comments or recall anything about that conversation?
I don't remember anything either, which is interesting because the point made kind of makes sense that somebody else is concerned. It may be in part not perceived to be a problem because whoever the affiant is does have to act as a fiduciary. So although that doesn't mean that somebody is not going to be disputing their ability to do a good job, they do have fiduciary duties in carrying that out.
And liabilities.
And liabilities. And so if they do take the property and run with it, they are subject to some consequences. From a family member standpoint, that might not be perceived to be enough. But I agree, Lane, that it wasn't, I don't remember that any concerns raised in the discussion.
I remember a conversation that just the 10 days seemed like just an extra time to have to wait. And the general sense was that better to move, be able to move sooner than later. I suppose there's also the issue of, dissipating assets or assets that are declining in value. It kind of cuts both ways. So I think that was the general concern. Not a lot of, although I will say, and this conversation touches on it, if you look too closely at the small estate affidavit, and this is what, the judges will tell you, there are lots of ways for people to do really hinky things in a small estate proceeding and no one to know about it. And I think there are judges who would just assume we not have a small estate affidavit because of the because the authority affiants have with really very little to none oversight unless somebody has the wherewithal to cry foul and bring an issue to the court. But we have it and we live with it. And I guess the way we cabin the liability is by the limits in value. And I think we've increased in this case protections by explicitly stating the fiduciary responsibilities and liability of the affiant and other provisions here. But really and truly, there are lots of ways for someone to do some bad things in a small estate.
And that was discussed, that whole concept.
Yeah.
And here it seems that if you want to object, it'll be after the property, after you turn over the property, or you will be liable for attorney fees.
Or in this case, I suppose, if you, in your situation, if you think you really have a reason not to turn this over because this person, is untrustworthy and should not be handling money, I would expect that would constitute reasonable grounds not to turn it over, and probably not, it probably would excuse you from attorney fees. In that case, your defense may ultimately raise questions as to the propriety of the affiant to be serving as an affiant. But yeah, it's just hard to say in the abstract. Again, I know there was consideration about the 10 days just being another risk to assets if you've got a market that's declining in value or something like that. And so I think on balance, the group felt like that 10 days was probably not necessary. Mark?
A question more out of curiosity. In section 7, there's a required notice to the Department of Corrections if someone may have been incarcerated within the last 15 years.
Yeah.
What's the purpose of that?
Yeah, that was from one of our work group members who represents the Department of Corrections at DOJ. And that is because the Department of Corrections has the ability to make a claim, just like DHS for public assistance and those kinds of things. I guess that 15-year period is the period within which corrections can make a claim against an estate for costs of the incarceration. That all is in current law. This just gives them notice so that they have the opportunity to file the claim. Yeah, that's a good question. Some people pay close attention to these things.
Okay.
We had a wide representation of both on this group. So.
Yeah, that was counsel for the Department of Corrections who raised that. Any other questions? These are excellent comments, and I promise to take them to heart as the bill moves forward and accommodate them if we are able to. Okay? Then the last one is LC 2962, wrongful death, another area that seems to get by as much on myth and convention as anything else. The wrongful death proceedings exist in two places. Well, of course, wrongful death is in Chapter 30, but a personal representative has to be appointed in order to pursue a wrongful death claim. So that implicates our probate statutes, but there is not good linkage currently in the statutes between the two. Technically, a wrongful death proceeding is, if that's all you have, is a no asset estate. Because a wrongful death claim is not an asset of the decedent's estate. It is, and the benefits don't pass under the decedent's will. They don't necessarily pass under the laws of intestate succession. Chapter 30 defines who the beneficiaries are of a wrongful death claim. And so the beneficiaries in a wrongful death claim are a different group than the decedent's beneficiaries under a will, or possibly even the decedent's heirs at law. We have done in 2962, we've kind of created a crosswalk between Chapter 30 and our probate statutes to help better define how they interrelate. And we've also included, because there's a connection, some provisions relating to personal injury actions. Now, a personal injury action is an asset of an estate because the damages in a personal injury claim are payable to the decedent for pain and suffering and for damages that were occurred prior to death. And so those are actually the asset of an estate and would pass under the decedent's will or laws of intestate succession. But we've in Section 1, we've provided definitions that are particular to this, and it's important to know that we are defining beneficiary according to the terms of those people who are entitled to benefits of a wrongful death claim under Chapter 30. This is different than beneficiaries under intestate succession or under a will. In Section 3 and 4 relate to court approval of a settlement of both personal injury claims and wrongful death claims, the information that needs to be presented to the court in order to obtain court approval. Of course, some personal injury claims in estates and some wrongful death claims are resolved by trial. Most are not. Most are settled. And we don't have clear guidance as to the process by which the personal representative and the defendant, for that matter, get court approval of the settlement. So this statute creates very explicit provisions. And I would say that for this bill, we augmented the work group to include attorneys who specialize in wrongful death cases and PI claims to help us understand what the current practice is and what the deficiencies are that could be remedied by some clarifying legislation. So I would not be competent to have addressed wrongful death claims in particular, but I do want to assure the Commission that we had several wrongful death attorneys. That's kind of a gruesome. Several attorneys,
Specialists in that area.
certain attorneys who have substantial practice in wrongful death claims and PI claims assist us in this. In Section 4, we make clear that we just, again, trying to streamline probate, since a personal injury claim is an asset of the estate, but it's not like any other asset. We have deferred the bond requirements for a personal representative if a personal injury claim is the only asset of an estate. You don't have to file a bond until the claim has been approved and you actually know what you are administering, what the estate is. And then while a personal injury claim is being prosecuted under Section 4, Sub 2, you don't have to file an annual accounting, you just file an annual status that we're still working on the case. Sections 5 going forward to the next set are particular to cases of an estate being filed for the sole purpose of pursuing wrongful death claim. And I would say that there are intersections here between this and provisions of our first LC 2957, because a wrongful death, if you're filing a wrongful death an estate with only a wrongful death claim, it is technically a no asset estate, which is what 22957 addressed. So, assuming both of these LCs move forward together, the last thing Legislative Council will do will be to draft amendments that tie these two together. We don't have two separate bills amending the same set of statutes. So LC knows that assuming both bills go forward, they will be amended so that they intersect well. In Section 5 of the wrongful death claim, if it's a personal, if it's only wrongful death claim, you basically file a no asset petition. And in that case, the people who you notify are the beneficiaries of the wrongful death action. To notify them that they may be beneficiaries. Again, the devisees under an estate under a will have no interest in a wrongful death claim. So if the only asset of no, it's not even asset of the estate. I got to watch my language there. If the only purpose for filing the claim is to prosecute a wrongful death action, you notify the beneficiaries under Chapter 30. Let's see. And then we do have information to DHS because DHS has an interest in this. And of course, you file you provide information to the beneficiaries under the wrongful death proceeding. That's all in Section 6. Section 7 addresses the waiver of the typical probate requirements. Again, when all you have is a wrongful death claim, it's very much like we have in 2957. These are the provisions that will be harmonized between the two bills. The process for closing an estate in a wrongful death claim in Section 8 is different than an estate because you don't have estate assets, you don't do a formal accounting, but you do have to file a petition showing that you have made the distribution pursuant to the court's approval, and you give notice of that to the beneficiaries. And it's like a final account, but it's different because you're not accounting for estate assets. You didn't have estate assets. In Section 9, we have a provision that when damages are paid, they have to go into the lawyer's trust account either for the estate or for the lawyer representing the estate on the wrongful death claim, or on order of the court in a protected account. That was clarification that counsel for the handling wrongful death claims thought was important for the courts and for the bar. So that really addresses the wrongful death proceeding, which is really a species of a no asset estate, but with some particular elements relating to the relationship between probate and Chapter 30. Are there questions about that before we move on to Section 10? Okay. Section 10 is an amendment to the personal representative fee statute, ORS 116-173. In that statute, and this was the product of a commission bill either maybe in 2017, where we said that in calculating the personal representative's fee, and of course that's based on a percentage of the estate subject to administration. The statute has been woefully inartful in describing what that means. We were more particular about describing that a couple of years ago, and basically what we said was you take the highest value of an asset during the course of administration of the estate, and that is the value that you use for determining the calculation of the PR fee. There was a concern raised by an attorney in Corvallis. Well, what if you've wildly overstated the value of an asset? Then you get to use that for calculating your fee. That's not fair. So what we've done is we have said that the fee, the value that you use is the highest value of the asset that is correctly stated. So that if there's been a material misstatement of an asset, that value may not be used for the purpose of calculating the PR fee. You have to use the correctly stated asset. Sometimes that value may be corrected in the file. Maybe one thing in an inventory may be corrected when you get to filing the final accounting. In that case, if it has been misstated, then you have to use the lower value of the correct value. If you have a case, however, where you have an asset valued at one level, maybe because of a market decline, if it's stock, or if you have some casualty loss to an asset, it may decline over the course of the administration of the estate. This statute does not require that the fee be recalculated. You're still entitled to use that highest value because the PR was at a point during the administration of the estate at risk with responsibility for the asset of that value. So this doesn't apply to an asset that may decline in value, but it applies to an asset where it was materially misstated as of the date that the value was represented by the by. I think that's a clarification that will. I'm not sure what it is, but we've done it. And there it is. Any questions on the rest of 2962? If not, I think just again, in the interest of moving this forward, I would entertain, I think we take all three of these together, a motion to approve advancing LCs 2957, 2960, and 2962 for introduction as bills at the request of the Oregon Law Commission, with the report to go forward, again recognizing the report may be revised as amendments are made before the final hearing, but what you have is substantially the report. And with that motion, I would recognize that we have had requests for clarification and possible amendment on certain elements of 2957 that we will carry forward with the bills. Is there a motion to that effect?
So moved.
Thank you. Is there any discussion? Hearing none, is there any objection? That motion is declared passed then unanimously, and these bills will go in. So thank you very much, Commission. We've done our work getting these bills in for the session. Sandy, I think I want to turn it over to you with update and PK, Commissioner Runkles-Pearson, whichever one of you wants to update us on the Capital Workplace Harassment or Harassment Work Group.
Yeah, PK had suggested that she provide an update, so we're both qualified to do that, but.
Yeah, I'll jump in if I miss anything, let me know, Sandy. So since our group approved the report to the legislature, we've transmitted our report to the leadership, along with a cover letter. All of that information is available on the website for those of you who want to see that. In response to our report, the legislature has created a joint committee on capital culture, which has now met several times.
Every Wednesday at either 5 or 5:30.
A lovely evening time that all of the members appreciate greatly. And they asked me to come and present to them the report, which I did, and I gave pretty much the report that I had given to the Joint Legislative Administration Committee earlier. They then have asked me to return several times, and I was there again last week. They are piecemealing the recommendations in the report into bills and or rules as they deem appropriate. It's a bit of a process that they're not quite used to because they're used to having someone be the proponent of a bill, and in this case, they don't really have a proponent. They just have this raw material that the committee is working on, and they are having public hearings on some of this stuff. So all that information is obviously available for you to see. The bills that they have forward so far are the bills that would create this joint equity office that we recommended, and then also a bill that would confer statutory privilege that would enable folks to make confidential reports. Every time that I have appeared, and Lane appeared also with me the first time to talk about our work, I've made very clear that my statements, to the extent that they reflect what's in the report, they are talking about what the Law Commission said, but otherwise it's just my opinion, so I don't want anyone to feel I'm willy-nilly running forward representing my view as the view of the Commission. But I think that they do appreciate the guidance that has been provided so far. Sandy, anything to add?
No, the only thing to add is, in my role as the director, I'm following the proceeding to make sure that the committee doesn't need any interpretations from any part of the report that was passed. I know at least one other member of the work group has been asked to testify several times, Sam Meyer, in support of or based off her expertise, but also in support of the work we all did together as well. You know, if there's any guidance from any commissioners about what role the commission should have moving forward in this process, because this was an atypical project for the commission to embark upon, please let me know. I'm happy to have a discussion about it. At this point, I'm only advocating for them to ensure that they understand what we've given them. And for example, Representative Williamson, one of the chairs, had asked for an interpretation of liability associated with having a better understanding of what interns work in the building. So I helped to facilitate working with the UO General Counsel's office just to make sure that she had a better understanding of what that might look like from an institution. So that's the role I'm taking, really as a facilitator that we spent all the time and we worked on this process to get something to them, but not necessarily, as PK said, not necessarily advocating for any decisions they're going to make, because in the end it's going to be their rules that and by they I mean the legislature itself and the building are going to have to follow.
Okay, let me open it up to questions. In the room, I also want to acknowledge that Judge Egan has joined us a few minutes ago, so welcome Judge Egan, he's in the room. We have 5 members on the phone. Are there questions? I have one, and that is, how's it being received, and are we getting pushback on any particular elements of the recommendations?
I think so far it's being very well received. And every time I appear, people are very grateful for the work that the commission has done. We did get some, we have gotten some pushback. Some of it has been more in the form of questions of how is this going to work. There were some questions the first time around about how to balance the idea of punishment for statements that one makes that might be deemed harassing with the idea of free speech. As I told Sandy, I'm doing a whole CLE on that tomorrow night, so they can come to see that. But, you know, I think our response to that was that non-discrimination laws already exist in Oregon statute. This is not a new problem. This is just a way to comply with existing non-discrimination law. And to the extent that someone would be getting up and making some kind of statement in the context of a political debate, I find it highly unlikely that that would be considered harassing to the extent that it's focused on policy considerations. The second issue that we've seen a little on was in the last session, a number of folks came forward and testified in opposition to the confidentiality provision. I think that there may have been some lack of clarity about what was intended by our recommendation. Some folks seem to believe that confidentiality meant that someone who came forward with a complaint about harassment would be forced to remain silent. Whereas the confidentiality was meant more in the form of a privilege that one would hold if you came forward to make a complaint that you wanted to make in a confidential way, similar to other privileges that we know about, like medical and attorney-client privileges. Some folks also testified that they wanted to be able to make a confidential report and then have disciplinary action taken based on that report without anyone having to come forward. I think what our report would say about that is that that's a fairly substantial due process problem, that a person couldn't very well be disciplined without knowing what it was that they were being disciplined for, or, you know, with the opportunity to confront the person. So on that last issue, the confidentiality issue, Jackie Sandmeyer, as Sandy mentioned, who is on our group, has a great deal of experience with this area, having been integrally involved in a similar privilege that was put forward a couple of years ago involving campus victims advocates. And so she testified, they testified at the end of our bill last time, talking about the substantial increase in reporting that has come forward with the confidentiality, both confidential and non-confidential reports. And they have been invited to come back next time to talk more about that and provide more statistics. So I think the folks in the committee are very interested in hearing more about how this previous privilege has worked, and I think that they're open to the idea of creating one.
All right, thank you. Other questions from commissioners?
Mr. Chair, I have a question.
Yeah, Commissioner DiLorenzo.
For PK, John DiLorenzo here. Has anybody made any fiscal estimates of how much the office that the reported visions will likely cost?
I've not seen a fiscal impact statement yet, John.
And John, I have not either.
I
Does
would
anybody
assume-
have?
Oh, go ahead.
Does anybody have any rough ideas?
I do not.
No.
I would assume that whatever this committee recommends, to the extent it has fiscal impact, will go through the Ways and Means process like everything else. And that's where good policies go to die sometimes. I guess it's just, it's a question of what their priorities are to fund.
I mean, John, one thing I could make a guess on, if you want to talk later, on what the staffing might cost, because I think it would likely, I know that area from folks who are both in the higher ed world and others, but in terms of how they would construct that within the building, I have no idea.
And John, your
Well-
question actually brings up one other area of discussion that has happened with the committee. There are some committee members who seem to be concerned about the idea of having an internal office as opposed to outsourcing this function to some sort of contract or outside agency. And that was a topic of discussion in our work group as well. I think it's healthy to discuss, and we'll see which way they come out.
Yeah, well, Mr. Chair, I think it just might be useful to have some idea of how much the office itself might cost in advance, because I could just see this proposal get downstream a little bit, and then all of a sudden, fiscal comes back with a huge number, and some legislators then use that to justify not proceeding with the proposal or large portions of it. And quite often a large fiscal becomes an excuse for inaction.
Yeah.
So I just think we need to keep an eye on that.
And I'll ask Sandy to be in touch with you, he's saying he's got his guesses. Of course, this one, we don't know how the legislature would actually staff it, set it up. And unfortunately, the only people I know of who are authorized, who have the ability, really, to do that kind of calculation are LFO analysts and budget analysts in the agencies. So I don't know that we have the capacity in the Law Commission to make that kind of an estimate. But I mean, I accept and agree with your concerns that love them in policy committees, and swore they never heard of them when they got to Ways and Means. So I mean, that is a risk, and I guess it's just, in my mind, going to be one of those things that the legislature is going to have to balance in this session when it comes to prioritizing where they spend their money.
Mr. Chair, I
Well,
can certainly raise that with Josh Nasby as well.
Okay.
Those of you who heard, Josh Nasby was the staffer that the legislature provided to us for our work group. He has now been assigned to be counsel to the committee as well, so there's some nice continuity there.
So John, I'm happy to see if we can find some numbers.
Yeah.
Yeah, John,
And-
I'll work with both PK and I apologize.
Oh, go ahead.
And
John.
PK, it might also be appropriate for the committee to ask the co-chairs to maybe determine whether they can lend somebody from fiscal to the committee itself to just prepare some estimates of what various alternatives would look like. It might be better knowing that in advance than saving it to the end.
That's a good suggestion. Thanks, John.
Yeah, and my recollection of the process is even in a policy committee, a bill doesn't get out until it has both a revenue and a fiscal statement. So they are going to find that out. But your question is sooner than later, I suppose.
And
Yeah.
John, the one thing, I'm going to be there tomorrow night representing the commission, so I'd be happy to at least make sure it's on the radar of the chairs and speak with Josh about that concern.
Okay, thank you.
Good. Anything else? And I would guess, just in PK, I appreciate your comments about how you present to the committee and Sandy as well. I would say, just in the tradition of the commission, even though this is a different product, the report constitutes the spoken voice of the commission, and I think that would, include reasonable interpretations of the printed page. And to the extent that you're asked to do more or other than just what you're doing, to clarify that this is a position or a statement that you're making in your own behalf and not on behalf of the commission, I think is the way to do it. And if sometimes it happens in the process of a bill, even where a proposed amendment is so substantial that we feel like we need to take it back to the commission to make sure that this is still a commission bill before it gets out. We'll leave it to your good judgment to know if they're proposing something or they want something out of the commission that's not in the report. Then you bring it back to us, and we can either reconstitute the work group or reconstitute the commission to try to answer something that that they want to know from the commission.
Believe me, I'm being very careful. When I get up there, the first thing I say is that caveat, and I'll keep an eye on whether any official additional statement might be necessary.
Yeah, as I say, that's something we deal with bills all the time. They do get amended, and we just have to make judgment calls whether an amendment is so substantive that it has to be brought back to the commission for approval. Sometimes we do it, sometimes I decide that an amendment is not so substantial.
Well, and this is particularly challenging because although we made policy recommendations, we didn't recommend any particular bill.
Right.
Every time I have showed up, I've said, we're not recommending a bill, these
Right.
are our policy considerations.
Yeah.
So,
Okay. All right, well, very good on that. Let's go to number 6 on the agenda, status report on other projects.
Yeah, we'll walk through, we have two groups that have been put together and two that are still being put together, so we'll kind of talk in that order. We'll start, Mark, since you're in the room, we can start with the Notarial Acts Work Group, which we did have our first meeting a couple weeks ago. Mark, do you want to discuss that?
Sure. We were not successful in making it a one-meeting work group. We had a great discussion because we had one of the uniform law commissioners and the reporter for the uniform proposal who were on the phone and gave us a lot of information, and I think that the work group had a couple of questions that they wanted to find out a little bit more, one of which is how is this faring in other states that have adopted it, because there's a half dozen or so that have or are in the process of doing that. And I think that the concern is, since this concept of remote electronic notarization is kind of out there, it has some jurisdictional concerns from the Secretary of State's office. It has, I guess, concerns of estate planners, really about, okay, this durable power of attorney, are you calling up some call center in Texas to have this thing notarized, and how does that really work? And you know, there's the real property closing folks that are wondering, okay, is that going to be a call center in Plano, Texas? Also, yes, I'm picking on Texas, but
Go ahead.
Yeah, that was kind of the concern there. So what we're doing is we're going to have another meeting in mid to late April, sometime in April, to kind of address those issues.
Good.
And I will tell you that there is a different bill that's being that has been I think they've had one hearing already that is proposed by either the mortgage bankers or the credit unions to allow for electronic signings. This bill would be able to mesh with that bill for the remote electronic notarization, but that bill does not go as far as this concept.
Good.
But
Well, you know, I would just say, I'll just offer, April, just gauge, I guess, your sense of the progress. If we've got a bill with a relating clause that works, we could, and you get to a resolution in April, we might be able to find a train still on the tracks to hook up to, if it's feasible. Yeah, and yeah, it's interesting. This is, to me, I'll say it's a brave new world. I mean, there are lots of things that we're doing that shock me. By the same token, I think Susan can probably relate to this in the bar and the practice of law. The world of technology and what can be done is moving ahead without us. So we just need to try and get comfortable with what modern technology makes possible and capture as much of it as we can and provide protections.
Lane, can I add one comment?
Yes. Oh, yes, reporter for the Uniform Electronic Wills Act committee.
Yeah, there's more coming. It gets scarier. But my comment is just for the April meeting. One of the things that we had at one of our electronic wills drafting committee meetings was a presentation by someone from one of the e-notarization organizations. And it's really impressive what they do. I was, quite nervous about it, as many of the estate planning lawyers are, thinking that this was going to be scary and potentially a way for things to get notarized fraudulently. And there are actually a lot more protections using e-notarization than there are currently under the system that we use, which it's hard to kind of get a sense of without that little. They have a video and they show how it works and the whole process and what's involved. So if you can use something like that at the April meeting, I found it really helpful, and I think it would be helpful to people attending that meeting.
Yeah.
Thank you, Professor Gary. We'll certainly see what we can do, because we were talking concepts.
Yeah.
And we didn't have any, FaceTime show of what we're doing.
But yeah, we certainly could have the technology for it. And I think, Susan and Mark, the one aspect which we talked about, which is really a technological improvement, is it would actually physically record the actual signing, which doesn't take place now. So that, in terms of a lot of the folks who were concerned about, I know folks who work with elder law were potentially concerned about that, about having some external pressures from folks in the room, things like that. The fact that there would be a recording, but Susan, it'd be really helpful for people who are on this work group to actually see that take place. So I'll work with you to try to find that video and certainly present that.
I'll get the information. I wasn't the one who set it up for us, so I'll find out who it was and what we can do.
So Susan, do you know offhand, was that demonstration a demonstration of using the protocols in the Uniform Act?
Yes, but
okay.
it was presented by a company that does it.
Yeah, okay.
So there was somebody there in person, but they did have a video that I'm hopeful that we would be able to use, kind of showing the whole process from start to finish.
Yeah, I was just curious to confirm that what you'd be watching would be what the act would prescribe.
Right. I'll confirm that, but I'm pretty certain that's the case.
I'm guessing that would be the case if you saw that at a Uniform Drafting Committee.
Right.
Yeah, and really and truly, folks, if you think remote notarization is scary, wait until you see Susan is the reporter for the Uniform Law Commission Drafting Committee on Electronic Wills. So prepare yourselves. You'll be bringing your smartphone to the courthouse to show the judge the will.
Won't even go to the court.
You won't even go to the courthouse, of course, that's right. You'll just send it. Wow. Okay, Ann.
Yeah, the next group, which has been convened and we had a meeting scheduled, unfortunately we had to cancel the first meeting due to weather in Portland. The LLC modernization work group, and this is chaired by John DiLorenzo. I don't know if John, if you want to talk about it at all. We do have our next meeting rescheduled for March 1st.
Yeah, we unfortunately were unable to convene because of a snow event, but we do have the work group fully formed, and I have decided that I'm going to make the work group work through lunch, but Davis Wright is going to supply lunch. So
Right.
we're all ready to roll.
Great.
Great, and just for the commissioners to know, this has been a really wonderful collaboration, creating this group with the Oregon State Bar and specifically the business section. And they're really helping, they help to find people to be a part of the group and also help lead the group in a direction that we really feel a lot of success. It'll be a long-term project, but everyone involved is very excited to move forward.
Long-term, you got a Uniform Act, just vote it out. Isn't that the way it always worked? Never.
There are three other projects that the commission has approved that have not started yet, but I can tell everyone what the status of those are. A really easy one, and I think Keith is still on the phone, but this is the project concerning e-hearsay rules. This was the one that we needed the most research ahead of time to really even understand what direction we were going in. And Keith and I had a great conversation yesterday. It was something that Lana had spoke about before, and potentially having some really solid research done before we even get started about where these rules are in other states, what work has been done in this area in other states, and the current status of the law in general. It's a constantly changing area of law, and we're looking to do that. So what with Keith and I spoke, and Elaine, we've spoken as well, is to work with the University of Oregon to hopefully find some law students who would work in collaboration with a faculty member at UO who would do a comprehensive research project on this area that would be a report to the commission to give us a really strong basis of where to start. Then it would be reviewed by Keith, who would be the chair of this group, and the full commission to figure out what direction we wanted to go when we would finally start to work on a statute. Keith, did you want to say anything more?
I'll jump in. That's a good summary. I think it's a great idea for us to get some initial groundwork done by some of the law students. First, it's a great opportunity for these law students to do some really interesting research, and for us to be able to identify the question or the problem, we need to figure out what has been looked at and addressed, if anything, anywhere else in the country, and that might help us streamline the work that we need to do. So the idea would be to have the law students take a look at how, if at all, other states have addressed electronic document admissibility issues. And we may find that there are different ways that states have addressed it, both in the criminal context and the civil context. And having that kind of background will influence the people that will become members of our subcommittee. We already have a number of recommendations, so I'm creating a short list of people. My hope is that we'll get the research done before the end of this semester so that come summertime or early fall, we'll be able to actually start some meetings and discussions about what, if anything, we want to do here in Oregon.
Great. And based on my discussions with folks at UO, it seems like there's a really good opportunity we can find some quality students to work on. So my goal is to start that process of finding some people and then working with Keith to lead them in the right direction as soon as possible, and I'll continue to report back on that progress. Two other projects that haven't gotten the group.
Oh, just on that, Keith, you mentioned electronic documents. Of course, when I think of electronic documents, I think of a Word document that's saved in my computer. I'm guessing, as I recall from this, we're talking about something even more outlandish than that, things like Snapchat and those kinds of things.
Yeah, it's digital evidence, and
Yeah,
you know, I'm
okay.
not enough of a visionary to recognize what's going to come after digital evidence, but something is indeed going to be replacing what you and I know as paper documents, and obviously that includes email, but Snapchat, Facebook postings, Twitter feeds, all of that are digital information that is certainly crucial evidence in some cases. Just coincidentally, I wrote a law review article, not a law review, but a law journal article about this, and I was astounded at how many idiotic postings people make on either Facebook or Snapchat or Twitter. I guess I shouldn't when I follow the president's tweet, but they actually do come into evidence. But what's challenging oftentimes is that the perpetrator deletes his account, and so then the prosecutors have to figure out some way to get the information. They don't know what's out there, and so it's an interesting process of trying to identify, is it the original, is it fair and accurate, you know, how do you prove up a digital image And that's kind of the process of discussion of what kind of elements of proof are necessary to get that into evidence.
Sounds like fun.
Yeah. The other two, one of them is the project with direct criminal appeals. Forming that work group was a little bit more difficult than I expected because a lot of the people who were involved in the past moved on to different positions and trying to make sure that all those groups are represented. Still working on the final touches of putting that group together. We hope we can get that group reconvened as soon as possible. During the session, as you all know, it is hard to get a lot of people who are involved in the legislation serve in a work group, but that's one that right now is on the top of my list of reconvening that group to work on the second phase of that project.
Has Jim Nass written a roadmap yet for this?
Yes,
Okay.
I do have that.
Good.
So it gives us, we do have a roadmap moving forward. We have several names of people who want to serve moving forward. Continue to pass those along to me if you do have other people who would be interested or be a good representation of various parts of the legal community. Deal with criminal appeals, and especially with the second phase of the project, be with municipal courts.
Right.
So if you have, I do have some names, but if there are others who you think might be interested, please let me know, and I'll work with to help get that formed. Also, if there's any commissioners, yes.
Oh, I just have a question. As somebody who's new to this project, can you explain what you mean by direct criminal appeals?
You're no more than me.
Yeah, well, actually, maybe I'll take a stab at it and then let our judges. The first part dealt with two issues. One, what's in criminal cases, what is appealable? Among the myriad orders and judgments and things in a criminal proceeding that are determined, what is appealable? And then the second issue was what is reviewable. And before our work group on this first phase, there was a morass. The case law and statutory law and tradition and word of mouth. We hope we have clarified the issues of what is appealable and what is reviewable in criminal proceedings. There is another type of proceeding that is called special proceedings. And help me remember what Jim described in the way of special proceedings. Are they things like forfeiture orders, things that themselves are not criminal, but that are related to?
We call them special statutory proceedings.
Yeah, special statutory proceedings.
Written review.
Yep.
So other things where the path of appeal and reviewability is not clear. And so those are the kinds of proceedings that this next phase is intended to look at and clarify. And then the third phase is, and municipal lawyers will love it, and it's to better describe how appeals are taken from a municipal court to the circuit court, because that's a whole different world of appeals that again exists in one or two statutes and not very clearly or helpfully at all. So does that help?
Thanks, that's very
Okay, good.
And I have a memo that Jim Nass wrote, which I could pass along to all the commissioners. I'm happy to.
This was the proposal for the.
It was
okay.
for the stage 2.
Yes,
which is
right.
Special statutory
Yeah.
proceeding. To pass along to show everyone. I'm happy to do.
Why don't you resend that? It's been a while since we've looked at it.
Yep.
Okay.
And then the final one which has been approved, which we put on the back burner for a little bit, just as we're trying to, is a work group to be formed for collaborative law. There was, which is a process that usually, correct me if I'm wrong, but is usually associated with divorce cases, and certainly in family law, that involves a whole new set of rules for handling those cases, and especially for the attorneys involved. Again,
We know it well.
Yes. So we have for the bar in forming that group, and we're going to work very closely with the bar to make sure we have all the right people represented, and hopefully get that one started as soon as we're able.
It's another Uniform Act. Just pass it.
If only it were that.
I will say with that one, even having discussions with folks in law school about that, there's going to be a lot of discussion.
It's sort of like remote notarization. It's that brave new world that for a lot of us seems hard to comprehend, but it's there and it's happening. So what do we do about it?
So that's where we are in terms of the progress moving forward. This session, we're really focusing on permit bills, which we just approved, and working with the workplace harassment project. That really is imperative, and hopefully we'll have some bills ready for the short session in 2020.
Yeah, I'm excited. I think with Sandy on board now for the last year, and the transition having been made complete, chance of gearing up some of these work groups and having a fuller agenda of projects coming forward, I think we're back into that swing of things. So,
and I guess we are taking new proposals as well. I haven't got one in a while.
Bring them on.
Bring them on.
Yeah, I did hear about the Principal and Income Act, that there's an interest from the bar section.
I think they are interested in that.
Yeah,
They haven't approved.
I said it's a uniform act, just pass it.
I can tell this is a month. And again, we'll say everything's fine.
We've always done it thoughtfully. Yeah, no, I'm being facetious.
And one note before, I'm sorry, one note before I forget, and I've already had discussions with at least one commissioner about joining one of the groups which are convening. If any commissioners are interested in being a part of these groups, please let me know, and especially new commissioners, if you're interested in joining a group, and we can make sure that happens.
All right. And a final word on budget. We're in the judicial department's budget. So our future seems to be secure. It's a question of how big, how much.
I took a look. It's in the Chief Justice's budget. Our main request for the funding for the commission itself, and then we also have the option package where if that were to be passed, we would have funding to hire a staff attorney. The commission has had a staff attorney before, and was very helpful, especially when the commission's operating at full steam and has several projects going, to really be the point person. We'll see. I haven't really gotten any guidance on whether or not that's a realistic possibility, but it is in the budget as a request. And we're going to work, Elaine and I are going to work with the University of Oregon to make sure that the numbers are going to fit with their needs in terms of all of their liabilities with staffing. They have one of the changes, as I've spoken with the folks at UO, one of the big changes with the transition from Willamette to a public institution is the liabilities of a public institution for employee salary are quite different, having to cover things like PERS. So we want to make sure that the funding that we're receiving is going to be enough for us to move forward, but we feel good about it.
Yeah.
And we have not been scheduled for a hearing yet by Ways and Means, but we're keeping an eye on there.
All right. Any questions? Then thank you, everybody, for a productive and informative meeting. We'll be adjourned. I guess we'll stay in touch with you as these bills move forward, if we need to reconvene on anything, or if anything comes up with the workplace harassment or harassment work group, or that project, we will let you know. Thank you for your time and attention. Thank you.